25 minutes before 11 o'clock. Thank you for tuning in. If you have a legal question, this is a good time to call it in because John Fuller is in the studio. The show is called Legally Yours. Today is the 25th day of June. I tell you the date so that you know if you're listening to a live show or not, because now and then John cannot be in here because he's in court. But today, June 25th, 2014, John is here, and your calls are an important part of his show. The number to call if you'd like to speak to John during the course of these 25 minutes is the WOCA Climate Control Source Hotline, 622-9622. If you're out of the area, I see some people watching online. The area code is 352. So 352-622-WOCA. Good morning, John. How are you doing?
Good morning, Larry. Good morning to our folks who are listening to this program. It's always great to be here. I've missed one or two the last few weeks, so I'm glad to be back, and hopefully we'll get some calls. We try to answer folks' questions if they or their family or friends or loved ones may be facing some kind of an issue that involves a legal question. Obviously, if it's something specific, we would recommend calling our office, making an appointment, and we'll certainly deal with the matter one-on-one because details are important. On this program, we speak in basically general concepts about different issues that are of interest to the folks that listen to us. So it's great to be back. I hope you've been doing well and enjoying the torrential rains that we've had every day.
Every day. Yeah, it's a welcome thing because it cools it down, but
yeah, I guess it's welcome, although I'll be honest with you, I wouldn't mind a day or two break from it.
I know. I thought that too. A couple times it's been not the best time. So.
Well, people think, well, you work indoors, what difference does it make? But, when you go from point A to point B, you've got to leave the building, go to the parking lot, and we've had some really good rain. So anyway, I hope it's made all the people who are in agriculture or just wanted their yards watered, I hope it's made them happy.
When somebody gets a knock on the door from a police officer, and let's say the 13-year-old was out there with a BB gun and broke the law by shooting something with the BB gun he shouldn't shoot, like the stop sign or something. Is that whatever penalty could come from that? Does that justify hiring a lawyer, I'm not giving a real case. I don't know anybody going through this. But.
If someone who is a minor commits a violation of a criminal statute, they're handled in the juvenile justice system. And that's an area kind of all to its own, and I don't handle juvenile cases anymore, so I'm really not up on the latest developments. Juvenile law is a tough part of the law to practice in because it's a little bit conflicted. You have a duty, it has a duty to mete out appropriate punishment, but because of the fact that they are juveniles and they're youth, you want to try to do sentencing that remediates the problem. If they need counseling, if there are other issues, you try to the court system tries to ferret that out. I have done that work many years ago, but have not done it recently, so I couldn't answer that. It depends also on the nature of the case. Parents are responsible for the actions of their kids, and I defended a lady who was a single mother whose son got a BB gun for Christmas a number of years ago and shot the little kid down the street in the eye with the BB gun, and he lost his eye.
That's serious stuff.
Yeah, so that is serious stuff, and the parent can be civilly responsible for negligent acts of their minors. But I see we have a call.
Yes, sir. You do have a phone call. Good morning. You're on the air with John.
Hey, good morning, John and Larry. I got a question for you, John, about some things I've caught on the radio and on TV about social media crimes, such as if Larry threatens to flatten the tires, or that wouldn't be a good example. If Larry threatens to beat somebody up next time they see him, or if you're specifically slandered on possibly one of the Facebook or similar social media sites, that these things are starting to come to trial more frequently, and they're trying to determine how do you rule on this stuff. And I'll hang up and get the answer, John. Always good to hear hear you on the station.
Well,
Thanks a lot, guys.
Thank you so much for, number one, for calling, and number two, for your kind comments. I really appreciate that. And you're absolutely right in your observations, and I'm not going to be able to give you much insight into it, because what the law is a dynamic body. I mean, we had no automobile negligence or tort law until Henry Ford came along and made the Model T a mass-produced vehicle, and a lot of people had them, and one person drove his Model T in front of another person at an intersection, and there was a collision, and someone was hurt.
Yeah.
Prior to that time, you didn't have any cases on automobile negligence cases, because automobiles were a very rare thing that maybe the super rich may have had some early on, but it wasn't until then. So the law develops out of what's going on in society and what's going on in technology. And this is the same thing with social media and internet communication and texting and all of those things. We didn't have that 15 years ago or whatever. I mean, we certainly didn't have it where it was common and commonly employed by a large group of the population. Now that we have it, like anything else, it can be subject to abuse. The internet, or like the social media things, have certain rules and regulations that they try to control, but it's not perfect. I saw where some young girl in the media a number of months or years ago committed suicide because of things that were posted on the social media. We still have laws that control behavior, whether it's done verbally in public, whether it's done in a written letter, whether it's done on social media. We have anti-stalking laws, and those laws are now beginning to catch up with what has happened in our technology. The technology outstripped the body of law. Now they're starting to pass laws that make it a crime to harass or stalk through social media and that sort of thing. So we don't have a lot of appellate court decisions on it, and I can't give you off the top of my head any examples, but I do know that for things that would be considered slander, verbal assaults, stalking, threats, the same body of law that applies to someone who writes another person a letter and says, you better watch your back because I won't be following you and I'm going to get you. And every time you walk out your house, you see the person standing there under the street light. Well, we have an anti-stalking law now. That law's not been on the books very long, but the legal system ultimately catches up with what the issues are when the laws that are on the books are not adequate to deal with the nuances of the new evolving technology. I hope that is an adequate answer, but it is a matter that is a work in progress, and the law, you cannot have an appellate court decision unless there is a justiciable issue, a case in controversy. So you have to have two litigants to bring a case under a theory before it gets to the appellate court and they can issue an opinion on it. So that takes a while to work its way through the system. So we get a law, but it may be 1, 2, 3 years before we start seeing how the courts are interpreting and applying that.
Yeah, and it's a fascinating story. One of the stories we're following is a guy arrested for that very thing, and now the Supreme Court's looking at whether they should overturn it. We have a phone call.
Okay, very good.
Good morning. Thank you for calling. You're on the air with John.
Yes, good morning, Mr. Fuller.
Good morning. How are you, sir?
Very good. Thank you. Last week, I don't know if it was locally, but I think it was in the state of Florida. It was something that I never had ever heard before, and I just still can't believe it. But a judge fell asleep during a court trial. And had you heard about it?
I didn't hear about that, but you have to remember, I have practiced trial law in Florida and the southeastern United States for 41 years, and that case isn't the first case where a judge fell asleep in the courtroom. So
This judge was taking Ambien.
and yes, I have had that happen to me in my career, and it's troublesome, how to deal with it.
According to the article, the bailiffs removed the judge. I guess they couldn't really get him woken up enough. Now, what is the function of the bailiffs? Now, can they overrule a judge in a situation where illness might play a part or something else? Or do they have that authority?
Well, I don't know about the case you're referring to because I don't know any of the details and I'm not familiar with it. Certainly a bailiff cannot overrule any judicial act or intervene in the operation of the courthouse unless there is the appearance that there is a danger or someone is in some degree of distress. And if someone is you don't know whether somebody's asleep or whether somebody's had a heart attack or a stroke or some other medical emergency. And I would suspect without knowing any of the facts, that if there was a difficulty in arousing the individual, that it is the bailiff's job to protect the judge and maintain the peace and dignity in the courtroom. And by the way, I want to stop right here and say on the side, we've got an outstanding group of bailiffs at the Marion County Courthouse. Those people are there. They protect the public. They protect the judge. Tempers run hot in trials. They do a masterful job. Joe Wright is the Marion County Sheriff's Department. He's been there probably over 20 years. I think he's Corporal Wright. If I got his rank wrong, Joe, I apologize to you. He is a great person. He is knowledgeable. He's appropriate. He's courteous. And when he needs to be firm, he can be firm. And Joe's about 6'5" or 6'6" and all muscle. And it's a warm, fuzzy feeling when you're in a courtroom where there's a lot of hot blood and high tension going on, to see Joe sitting over there and know that everything is in good hands. And all of his colleagues are in the same way, men and women. And they lay it on the line and they work. They do a good job. But to answer your question, their job is to maintain the safety, protect the judge, protect the people who are there, and to maintain order. And if there is some type of an emergency, whether it's something physical or vocal between two antagonistic litigants, or whether it appears that somebody is having a medical emergency. So if something happens where a judge has a medical emergency on the bench or is unable to function, there's procedures in our rules that deal with, you would have to start the trial over again.
How is it determined how many bailiffs will be in any particular court case?
Well, I guess the judge has some say over that. I'm not privy to how those decisions are made. I know as a matter of practice and activity, each judge has a particular bailiff assigned to him or her. And that bailiff stays in that judge's courtroom. And if there is a high-profile case with a lot of potential hostility, passions are inflamed. I have been in a courtroom in a high-profile criminal case where the jury was going to return the verdict after 2 weeks of trial, and there was a lot of ill will between the two different factions that were involved in the case. And I bet they had 8 or 10 bailiffs in the courtroom, and they made arrangements so that when the case was over, one half of the courtroom that was on one side was asked to remain seated, and the other half was asked to vacate and leave the premises. And they gave them time to get out, get on the elevator, clear the courthouse, and then they let the other half out. They handled it very professionally, but they may have been, I don't even know, but at every door, at every corner of the courtroom, they were there. They must have been, they were extra security brought in too.
Wow.
Thank you very much.
Thank you.
Thank you for calling. It's a good question, and it gives us a good opportunity, and I always like to try to do this on this program, to give credit and to compliment those people that work behind the scenes at the courthouse, because the judicial system belongs to the people. Everybody working there works for them, and while it can be an adversarial arena, and no one likes to lose, inevitably in every lawsuit there's usually a winner and a loser, and these folks that make the court function, they're indispensable, and those of us who work there on a regular basis appreciate them immensely.
This is a good time to call John Fuller. We've got a good 9 minutes left and a nice hunk of time to get a question answered sufficiently. If you want to call, do it now. 622-WOCA is the phone number.
I do want to take an opportunity. We've been focusing on this because we've seen a number of cases like this. If you're in an automobile accident, remember you have to get medical care within 14 days. Don't put that off, because you will lose valuable legal rights if you do. And if you are in a car wreck, if you do have serious injury or someone in your family does, and you care to talk with us about it, we are more than happy to schedule an appointment. If you call us, we'll get you in really fast. But the most important thing is to take care of your physical injuries and don't delay. And that's a critical point in automobile accident cases. And we represent a lot of people who are injured in a variety of ways, and it is very important in a car case to go seek medical attention. It has to be a medical doctor, a doctor of osteopathic medicine, a PA for a doctor, or a nurse practitioner as the first contact in the medical profession. You can't qualify that simply by going to a massage therapist or a chiropractor or an acupuncturist or somebody like that. They changed that law about 2 years ago, and it makes a significant difference that you can lose substantial insurance benefits that you've paid for if you don't go and get seen, treated, and determine if it's a significant medical event within the first 14 days.
Can you reopen an automobile accident claim I'm going to give a real brief idea here. Let's say somebody is in an accident and they go within the 14 days and the doctor says, oh, here, this is all that's wrong, and you accept that that's all it is, and then maybe 2 months later you start getting headaches that you never had before. You go back to the doctor says, oh, wow, I didn't notice that when you first came in.
There's provisions that they can relate it back.
Okay.
But if you don't go in the first place, you've got a real problem. If you go and see the doctor, and then a month later or whatever, you have emergent symptoms that become much worse, and you go back to the doctor, he can relate that back.
Wow. And I guess we've all known a few people that have had that happen.
It happens a lot. In fact, one of the reasons, if you're in an automobile accident case, you have 4 years. The statute of limitations in a negligence case is 4 years from the date that you know or should have known that you were injured. The date of the event usually starts that. And the reason it's 4 years is because our bodies aren't machines. And a lot of times there can be a late developing or emergent type symptom.
Right. Yeah.
It can be an aggravation of a pre-existing condition that flares up. And so the law gives you plenty of time to ascertain what injuries do I have. I had a client who had a horribly fractured, dislocated ankle, had to have hours of surgery and multiple screws and plates, rods inserted, and was non-weight bearing, and then was on crutches for a long period of time. And the ankle started to get better. She was prescribed narcotic pain medicine because to control the pain. As the ankle improved, she noticed that her shoulder was giving her a lot of problems.
Oh, really?
She went to the doctor. It was several months later. They did an MRI. They determined that she had torn her rotator cuff, which he also related to it. But she didn't complain about her shoulder for a period of time. And the defendants tried to argue that it wasn't hurt in this incident, but she was taking prescription pain medicine. She, was dealing with a serious surgical problem with her ankle.
Right.
And then, of course, as she started to become more mobile, she was putting weight on these crutches, which, of course, then started to reveal the pain in the shoulder and the torn rotator cuff, which also necessitated surgery. And the doctor said that it was related to the initial incident. She had never had any shoulder problem before then. And that was 6 months after the initial injury. And it really depends on what the medical opinion is. And if the doctor, in his opinion, based upon the history, the physical, the examination, the diagnostic tests, all of the things that they do in examining, diagnosing, and treating patients who are injured and suffered trauma, the medical opinion is critical. And in this case, the orthopedic surgeon was extremely helpful and confident that the injury to the shoulder had occurred as a result of the initial incident.
And if the medical opinion is saying that the injury was from the accident, even if it was 6 months ago or whatever, why is that not enough? Why do we need to battle with an insurance company and get the courts involved?
Because experts can hold differing opinions, and in this particular case, the insurance company hired a doctor, an orthopedic surgeon, who works frequently for them, and examined and reviewed the x-rays, the MRIs, the history, examined the client, and offered an opinion that this was
contrary to the other doctor?
Yes, right.
Oh, wow.
And so now you have a disputed issue of fact, and the law says that the jury can give expert testimony whatever weight, sufficiency, and credibility that they deem appropriate, and they decide whether they want to believe doctor number one, who in this case was the treating doctor who was trying to help the patient, alleviate pain, remedy the injury, or whether they believed the other doctor. And the defense in those cases like to call the doctors they hire independent medical examiners. That is a terrible misnomer, which I always correct in the courtroom. They are litigation experts who are hired by one side. They don't treat the patient. They don't prescribe for the patient. They don't try to help the patient get better. They're there to render a litigation opinion. And we have had some spirited cross-examination about that in cases.
John, we're down to less than a minute, so
Well, let's not run late. I think last time I did. Maybe I need to give a minute back.
No, but I wondered if you could maybe give out your phone number and other ways to get a hold of you.
Our office number is 352-547-4292. Our toll-free number is 855-534-2565. The law firm is Fuller & Fuller. We have offices in the Villages and in Ocala. If you have a legal problem, if you've been in an accident, we'd be happy to schedule an appointment and talk with you about your individual case.
Thank you for sharing your expertise with us.
Thank you. It's always a pleasure. Thanks
for the
to our listeners and callers.
And call us if you need John's number repeated. We'll be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM, 96.3 FM.
Fox News Radio, I'm Pat O'Neill. A key Supreme Court ruling in the TV business. It goes against TV startup Aereo, which uses tiny antennas to offer broadcast network content to subscribers.
The 4 major broadcast networks filed suit challenging this company, saying that they violated the copyright rules. Aereo says they did not because they simply were allowing people to watch content online.
Fox Radio's Jared Halpern. Mississippi incumbent Senator Thad Cochran edging Tea Party choice Chris McDaniel in a primary runoff, but McDaniel may challenge it.
What they'll be looking for is people who voted in the Democratic primary, then crossed over to vote in the Republican runoff. That's not allowed under Mississippi law. If they find irregularities, they could challenge